Okay. Um, all right. So are you Kendrick O'Veal?
Yes, ma'am.
You are charged with evading arrest or detention with previous conviction, and that's from August.
From the very beginning, the judge wastes no time getting down to business. He identifies the defendant and confirms the charge on record. Moments like this may seem ordinary in a criminal courtroom, but they carry serious importance. The court must verify that the correct person is present and that the accusations are clearly understood. But what looks like a standard procedure can sometimes turn into something far more intense. For the audience watching, one question immediately comes to mind: is this simply another routine court hearing, or is it the start of a much bigger legal showdown?
31st of 2025. That shows that you were previously convicted of evading arrest or detention July 22nd of 2011. So that's what makes it a state jail felony. Then the indictment further alleges you were convicted of attempted robbery, a third-degree felony, March 28th of 2013. And after that was final, you were convicted of assault, a third-degree felony, September 11th of 2019. And so what that means in that case is that if you go to trial and you're found guilty, and those prior convictions are true, the range of punishment would be enhanced to a second-degree felony.
This is the moment when the situation suddenly becomes much more serious. The judge begins explaining something known as a sentencing enhancement. In simple terms, a person's past convictions can make the punishment for a new charge far more severe. A crime that might normally lead to a lighter penalty can quickly escalate into a potential prison sentence ranging from 2 to 20 years. It's a powerful reminder of how the criminal justice system works. In court, your past doesn't just disappear, it can come back and play a major role in what happens next.
Which is between 2 years and up to 20 years. Do you understand?
Yeah.
And then in cause number 25 DCCR 1777, you're charged with unlawful possession of a firearm by felon. And that is from August 31st of 2025. That indictment alleges one prior felony conviction, the one from 2019, but the state can file, and I anticipate they would file, a notice of enhancement because that 2013 was left off of that indictment. And so what that means in that case is if you're found guilty and if those prior convictions are.
And then comes the moment that completely raises the stakes. The judge reveals a critical detail. Because of several prior felony convictions, the defendant could be classified as a habitual offender. In the courtroom, that designation carries enormous weight. It can transform an ordinary sentencing range into something far more severe. Instead of a standard penalty, the possible punishment suddenly explodes to anywhere from 25 years to as much as 99 years behind bars or even life in prison. Just take a moment to think about that. A single verdict in this trial could decide the course of someone's entire life.
True, you would be considered a habitual offender with a minimum punishment of 25 years in prison, up to 99 years or the rest of your life. Do you understand? And then finally, in cause number 25 DCCR 1778. Once we get all these done. You're charged with a third-degree felony offense of deadly conduct, discharging a firearm from that same date of August 31st of 2025. It does allege those two prior felony convictions. Again, what that means, if you're found guilty and if those prior convictions are true, you would be considered a habitual offender in that case also, with a minimum punishment of 25 years, up to 99 years or life in prison. Do you understand?
Yes, ma'am.
In all of those cases, I have here on this tablet a plea bargain rejection in each case that you've signed with Mr. Parker that shows that the district attorney's office has made an offer, if you wanted to enter a plea of guilty in your cases, to go on, probably it looks like counts 1 and 2, or a 15-year term instead of that habitual. And so in 2 of the cases, a 15-year term, and then in
It's 15 on all, concurrent on all of them, Judge. Yeah, because at state jail is it.
oh, I opened the wrong one. Sorry. Hold on, y'all don't want me to do that. That's a 30.
Oh, that's my next one.
Sorry. Okay, so 15 years in all three cases.
Then the prosecution puts an offer on the table, 15 years covering all three cases, with the sentences running at the same time. In the legal world, this is known as concurrent sentencing. When you compare that to the possibility of spending decades in prison or even the rest of your life behind bars, some people might see this as a reasonable deal. But there's a serious trade-off. Accepting a plea agreement means giving up the right to fight the case in front of a jury. So the real dilemma becomes clear. Do you take the guaranteed sentence now or risk everything at trial and let a jury decide your fate?
That would run concurrently, which means together at the same time. Do you understand what the state has offered you?
Mhm.
And so you have every right to reject that offer and have all three of your cases set for trial. I just want to make sure you understand what the possible consequences are if you go to trial, what your options are if you wanted to enter a plea of guilty in your cases. And do you understand all of that?
Yeah.
And do you want to reject those offers and have your cases set for trial? All right, we'll get that done. I do want to, is there any reason to believe that these offers would change?
Not at all, Judge.
So, Mr. Oville, I want to make sure you understand that after today, unless there is new evidence that is discovered by either your attorney or the state's attorney, I will not accept these plea agreements again.
At first glance, this moment may seem small, but it carries serious weight. The judge makes it clear that once the case is officially placed on the trial docket, the current plea offer could completely disappear. In many criminal cases, this is a key pressure point. Prosecutors often present plea deals early in the process, giving the defendant a limited window to decide. But once the court begins preparing for trial, those offers frequently get pulled off the table. Now the situation becomes crystal clear. The defendant is facing a tough choice: accept the deal while it still exists, or move forward to trial where the outcome is uncertain and the consequences could change a life forever.
Once it's on the trial docket, it either goes to trial, you can plead open to the court, or to some different amount or negotiated punishment. Do you understand? Okay, so I will get your cases set for trial. Mr. Oakville, Mr. Parker has been appointed to represent you. He's one of the attorneys who handles a lot of cases for me here as a court-appointed attorney. With your permission, I can release him and I can appoint a new attorney today who could begin preparation for trial a little quicker. Is that okay with you? Okay, so Mr. Parker, you're released. Mr. Oakville, we will appoint someone today. They should be out to see you very soon to begin preparation for trial.
Thank you.
Thank you.